Didrik versus the Bank of New York Mellon. Okay, good morning. Still good morning, yes. All right. We are all set whenever you are.
Good morning, Your Honors, and may it please the Court. Amanda Chazal and Michael Huey with Stichter, Rydell, Blaine, and Prosser. We are here today representing the appellant, Mr. Douglas Didrik, who is the defendant in the mortgage foreclosure proceeding below. I'd like to reserve 4 minutes for rebuttal. This case presents 2 issues. The first issue asserts a fundamental error on the ruling denying Mr. Didrik's motion for leave to amend his affirmative defenses, which had been filed 2 business days after Mr. Didrik was able to discover the grounds for these defenses. Under the second issue, Mr. Didrik asserts that the New York Bank of Mellon failed to establish that it was the holder of the note with the right to foreclose. Turning to issue number 1, in a mortgage foreclosure case, the plaintiff has to prove that it was the holder of the note at the time it filed the complaint. A denial of a plaintiff's assertion in the complaint that it was the holder of the note with enforcement rights puts this allegation of ownership at issue. Here, Mr. Didrik denied the plaintiff's allegation set forth in the plaintiff's paragraph 5 of the complaint, stating that it was the holder of the note of the mortgage and entitled to enforce them. Mr. Didrik answered that allegation in the complaint that he was without knowledge and therefore denied the allegation and demanded strict proof therein.
But are you arguing that the trial court did not require the bank to prove standing at trial? It's my understanding that the court still required them to do that.
Your Honor, respectfully, I would disagree. The court stated that it essentially put us in a box to be able to challenge the original nature of the note because it denied our pleading of affirmative defenses, and by failing to plead this issue of authenticity, we had waived it.
Well, I'll just tell you, we just got the transcript today.
Oh, I'm really glad you got it, though. We've been following up diligently.
If you see me looking here, I'm not reading my emails or the internet. I'm looking at the transcript.
Absolutely, I understand, and I have courtesy copies. If that's easier, please let me know, and I'm happy to provide them. And Your Honor, so as we were stating, the court stated that we had waived this ability to challenge authenticity of the original note because we failed to plead it and that it had to be pled, and therefore we weren't able to plead it.
But if I may, though, in any foreclosure, would you agree with me that if the bank is proceeding, the bank still has to produce the original loan documents, it still has to show that they are entitled to enforce the note? I mean, it's still, they bear when just the fact that you bring in a lawsuit, you still have that burden, correct?
I absolutely agree, Your Honor.
So perhaps maybe the judge was perhaps thinking that way, that it's the bank's obligation to still bring that forward. So there's really no need for you to say the position, at least, that you're trying to say. Could perhaps that was the judge's ruling?
Your Honor, respectfully, I didn't interpret it that way. That's not my interpretation. One of the reasons why is because the court, while it allowed the defense to proffer the testimony of an expert witness, Mr. Kelly, the court did not allow Mr. Kelly's testimony into evidence based on the fact that the issue of authenticity of the note was not before the court, as it had been waived.
Okay, a couple of questions come to mind with that. What was, in reading that, were your clients taking the position that what was attached to the complaint, what is purported to be the original, you're taking the position that was either a forgery or that was not your client's signature? It was very difficult to understand. I think he was saying, well, it looked like it was an ink printer.
Your Honor,
jet printer.
Your Honor, you completely 100% just hit the nail on the head with the issue in this case, and that's parsing out the difference between authentication of the signatures, whether or not the signatures signatures or a forgery, or the document itself is the original note that was signed at the time that the note was executed. Our argument isn't that the signature is a forgery, it's that the document itself is not the original promissory note. And in negotiable instruments, which is what a promissory note is, you can't submit a duplicate or a copy. You actually have to produce the original document that was signed. And so that's exactly where we see the issues of misapplication of the legal standard of self-authentication. It's because of a broad application of self-authentication to the signatures, making a presumption that the document itself is the original, and distinguishing that those are two different apples and oranges, and two different arguments to be made.
Let me ask you this question, because there was an initial foreclosure that was dismissed, correct?
Yes, Your Honor.
In 2009. The bank argues that the original note was filed then. And then now they ask the court at this trial to take judicial notice of that original note, is that correct?
Correct, Your Honor.
And then the note that was introduced, was that purported to be a copy or the original?
Your Honor, the plaintiff in the trial court asked that the court take judicial notice of the original note filed with the clerk in this case. And that was part of the issue, and you might see it sort of played out in the transcript of, Your Honor, asking for clarification from the court what exactly was being judicially noticed. And the response to that given by the court was that the court is judicially noticing that the original note filed in this case was the response.
That it was filed, or the entire note, including its authenticity?
Your Honor, you also nailed the issue as well. The case seemed to progress as if he was judicially noticing the authenticity, because the other requirements seemed to be of the rules of evidence, and the standard of possession seemed to be circumvented by this ruling. And that is why it isn't further clarified, but it seems that at that juncture he was judicially noticing the original note.
Okay, but was a note signed by your clients introduced into evidence at trial?
Our argument is no, Your Honor, that it was not. A copy of a note that may have been signed by our client was introduced into, and I wouldn't even say that, I don't even think they moved a copy into evidence? I don't even know if they did. It's unclear a little bit on that issue too. But regardless, even if a copy was moved into evidence, that's not sufficient. You have to have the original document. And here,
does the requirement that the original be filed flow solely from Chapter 90, or is it a requirement of the substantive law of negotiable instruments as well?
Your Honor, it's negotiable instruments completely. I wouldn't even say that it's a product of 90 as much as it's, well, it is with best evidence, going in that direction. But mainly, the best evidence requirement comes from the fact that it's a negotiable instrument.
Well, I mean, the best evidence rule says if you're dealing with a negotiable instrument, you have to present it, but that's an evidentiary rule, right? It's not a rule that flows from the substantive law. Am I correct about that?
Exactly. Yes, Your Honor, you're correct about that. And that's
okay. And if that's true, and your client doesn't dispute the fact that he signed this note, but rather only whether the note that was presented was the original, is the trial court's error harmful if it's an error?
Yes, Your Honor, absolutely. You can't, in the world of negotiable instruments, you can't use a duplicate or a copy in place of the original. And what it's a helpful illustration is another negotiable instrument in the same classification of promissory notes is a check. And you can't take a check and make a photocopy of it and walk into a bank and ask them to cash it. You actually have to have the original check. A check is a negotiable instrument, and so is a promissory note. They're in the same classification. The same rules apply to both. So therefore, you can't use a duplicate in place of original.
Well, there is an exception to filing the original if there's a satisfactory explanation for the failure to produce.
To get around the best evidence rule, Your Honor, but not the rule of the statute and the standard and the burden of showing that you're the holder in due course requirement, which says possession. So that might get around the best evidence, but that doesn't get around the standard of having to prove the element that you have rights to foreclose, which you have to show that you're in possession of the note. So it's sort of two separate requirements. One is more evidentiary, sort of as Judge Lario pointed out, and one falls under negotiable instruments. Both have to be met and fulfilled in order to be able to foreclose on a promissory note.
But there's also what happens if the original note is destroyed.
Yes, Your Honor. In that, there are provisions allowing for process to work around that and to provide for such circumstances. The lost note counts, and the plaintiff in this action could have pursued this action under the lost note count and under those provisions, but it didn't. It said it was the holder of the original note.
Now, I'm curious because when you mentioned about judicial notice, I know there was a lawsuit filed, and during that time, documents were submitted, and then when that lawsuit was voluntarily dismissed, wasn't there a request for these original documents to be returned to counsel? Did that occur? And then when it was refiled again, when the court took judicial notice, and now that the transcript's in, that's why I haven't had an opportunity since just came in this morning. When the court took judicial notice, did the court take judicial notice of what? The original documents, or when it was where are they?
What's stated in the trial transcript, there's I think it's around page 24 or 21, if that's probably the most helpful page or language to look at to help, because I know you all just got the transcript, is this dialogue takes place. What is actually being judicially noticed? The plaintiff states within that dialogue that the original note filed in the 2009 action, the first action, was returned back to the plaintiff, and they resubmitted it in this action. He does make that comment. You'll see further down the dialogue that the question gets posed, what exactly is the court judicially noticing? The court says, I believe he says, I believe what I'm noticing is the original note and the original mortgage. And so even with his own language at the beginning of the I believe, there was a sort of cloud of uncertainty that loomed over the rest of the case, sort of trying to see what the result of that was. It became further clarified that it did have the effect of sort of circumventing these other evidentiary requirements when Mr. Kelly's was allowed to testify, the expert witness was allowed to testify as an expert, was allowed to proffer his testimony, but his testimony was not admitted into evidence, and the court's reasoning for that was because of this issue that authenticity was waived and no longer on the table, and he was able then to take judicial notice. So it's sort of a partner of the two. You'll see on page around 21 and 24, the court says, the reason I'm taking judicial notice of this is because of the presumption given to self-authentication and the fact that it was waived by failure to plead it. And we would argue that the failure to allow the defendant to amend the affirmative defenses was an error, given the fact that Mr. Didrik could not rely on this denial. During the trial, the court argued that the denial of this ownership and the authentic nature of the note was enough, in cites to the Fifth Circuit decisions, such as McGee and as set forth in the brief. The court denied this reasoning and said that the issue was waived. But given that, we assert that the court abused its discretion by denying Mr. Didrik this one and only request to amend the answer. Florida courts have said in case after case that denying leave to amend is an abuse of discretion unless it is clear that the privilege to amend has been abused, that the amendment would prejudice the non-moving party, or that it would be futile. Here, Mr. Didrick's request to amend was his first, and it was made on the first day after the factual basis for amending became known to him on the discovery deadline. So he wasn't abusing the privilege to amend, and basically that's because the original note was not filed with the court until Friday, which was the last day of discovery. Mr. Didrick filed a motion to amend on Monday. Second, it's not clear that the bank would have been prejudiced by Mr. Didrick's amendment. Any alleged prejudice to the non-moving party can be cured by continuance, even if the request comes for the first time just before trial under Florida law.
Was there a motion for continuance?
No, Your Honor, there is not.
Was there a motion to take the deposition of anyone who could authenticate the original note?
Your Honor, the deposition of Ms. Darla Martin, who was the witness who the court put on to basically get around to the business record exception, her testimony was taken. And at that time, it wasn't clear whether or not the note that the bank was holding on to was in fact the original note. It wasn't until the original note was submitted with the clerk of court that actually the
Is there any reason you all couldn't have asked to inspect it earlier in the case?
Your Honor, not that I see. It could have been. It's the plaintiff's burden to show that's the original note, and especially the fact that this case had already been filed in 2009, and then the court, and then the plaintiff filed a motion to and the court withdrew its complaint.
Okay, and you're about to go into your rebuttal time.
Oh, okay. Well, Your Honors, we find that it was an error to not allow the defense leave to amend their affirmative defenses, especially since the issue was authenticity, and which was the very linchpin of the entire argument from the very start of the case. It cut off the knees of the argument and circumvented the evidentiary requirements in the standard and the burden that's required with negotiable instruments. Thank you.
Thank you. And just to let you know, you have about 3 minutes of rebuttal. Okay?
Thank you, Your Honor.
All right. Okay. You may proceed.
Thank you, Your Honor. May it please the Court, Aaron Berger from Kelly Cronenberg on behalf of the Bank of New York Mellon. Your Honors, obviously my position is that the trial court did not err, and we are requesting that the decision of the trial court be affirmed on the points that were raised by appellant's counsel, that we did prove our standing in this case, that we provided substantial competent evidence to support our right to foreclose the mortgage at issue, and that the court did not err in denying the motion to amend and in granting our motion in limine. And just by way of some factual background and a little bit of direction in terms of the transcript and what you'll find when you have a chance to fully read it, is that, yes, there was a prior foreclosure action filed in 2009. Attached to that complaint, which the court, and these facts were addressed to the court and are in the transcript, is that the copy attached to the complaint in 2009 had a note that did not bear the blank endorsement, and that subsequently the original note was filed in that case. The original note was requested to be returned to plaintiff following the dismissal of that action. The request for judicial notice that was made by trial counsel below for the plaintiff, for the bank, was that the court take judicial notice that the original note had been filed and that the copy of the original note that had been filed matches the original note that was attached to the complaint in our 2012 case that bore the blank endorsement, and the copy that has been filed as of June 2014 as the original note in our case. Those facts are significant in that the case law supports that upon the filing of an action, if the copy of the note attached to the complaint bears proper endorsements establishing standing, and those endorsements are found on the original note that's subsequently produced, which there's no rule telling when that has to be produced, as long as it's produced before the final judgment, then that's sufficient to establish standing. The other significance is that Mr. Didrick was obviously on actual notice that the plaintiff had the original note. There's no lost note count in our 2012 complaint. There's nothing to suggest anywhere on the record in our 2012 case that we would be proceeding on a lost note count, or that we wouldn't be able to produce the original note. The original complaint in our 2012 case was filed in October of 2012. The answer and affirmative defenses were not filed until February of 2014. Current counsel for the appellant came in about April 2014 and didn't file any requests to amend the affirmative defenses then, hadn't served any discovery to request inspection of the original note. Again, there's nothing to indicate that we didn't have it, and we wouldn't be producing it at the trial.
But did the plaintiff have possession of the original note? Was it returned after the 2004 foreclosure was dismissed?
As far as we know, yes.
And why wasn't it admitted into evidence at trial?
Your Honor, it was admitted into evidence at trial.
The original note, or
Yes.
a copy thereof? Which one?
The original, Your Honor. The trial counsel below filed on June 4th or 6th of 2014 a notice of filing, and listing on that notice of filing was the original note, the original mortgage, an original assignment of mortgage, and a copy of another assignment of mortgage. And that's what was filed. And Your Honor, when the trial court was discussing the judicial notice issue, it was discussed that the judge would be taking judicial notice that the original note and mortgage had already been filed. There's some...
So it was in the court file filed with the clerk?
Yes, and at the time of trial, it's my understanding the court had the court record in front of him, and he made a finding on page 20 of the transcript. I want to make sure before we leave that the issue will be addressed. I believe we have the original note.
Okay.
So he was able to review the record, and determine that the original note and mortgage had been filed.
So what note was introduced through the records custodian?
A copy was identified. There was discussion on the record that trial counsel wouldn't be introducing into evidence the copy that he was having the witness identify, but it was identical to, and there doesn't seem to be any dispute at the trial court below.
Was the copy authenticated to be an exact replica of the original?
Yes, by Ms. Martin's testimony, there doesn't appear to have been any dispute about that fact.
Okay, so it was authenticated.
Yes, Your Honor.
So what you're arguing is, contrary to the appellant, is that the court simply took judicial notice of filing the original, but did not take judicial notice of the authentication of the original.
Yes, I believe...
That had to be proven, and it was proven.
Yes, Your Honor, I believe so. And I believe that the trial court, having the record in front of him, was able to look through the court file and see that there was an original document filed after the testimony. Or, I mean, I'm not sure when it happened. Like I said on the trial transcript on page 20, he says, I believe we have the original note.
So the original note that was filed, was that the original note that was reviewed by Mr. Kelly? Or did Mr. Kelly
According
review
to his testimony, he went to the Collier County Courthouse after it was filed and reviewed it based on what the clerk gave him. I don't know
All right.
exactly. Sorry, one moment, Your Honors. And with regard to the argument that the original note was not introduced into evidence, Your Honor, I would reference Deutsche Bank versus Clark, 87 Southern 3rd 58 out of the 4th District, a 2012 case, where a similar situation happened. The original note and mortgage had already been filed in the court, and the argument was made that, and the trial counsel requested that judicial notice be taken that it was filed, and the court found under the best evidence rule that the admission and surrender of the original note, in addition to the identification of a copy at the trial, was sufficient to introduce that document into evidence. And the trial court did state, upon taking judicial notice and the discussion that happened on the record, that those documents were received into evidence.
What case cite that, please?
Sure,
What's the cite?
Deutsche Bank versus Clark,
I got it.
87 Southern 3rd 58.
Thank you.
You're welcome. The original note was also submitted as I've stated that it was submitted with the original mortgage and the original assignment of mortgage. There wasn't any proffered testimony from the expert that the other documents that were filed were not originals. And Your Honor, on page 96 of the trial transcript, and part of the proffer of evidence there, he does make reference to the fact that there were 2 colors of ink on the document that he reviewed, black ink at 300 pixels per inch and blue ink at 1200 pixels per inch. So I'm not sure that, it's questionable as to whether or not his testimony had helped at all in determining whether or not the original note was there, but there's testimony from himself that there was potentially a blue wedding signature on the document. Your Honors, it's clear from the record that in plaintiff's position or bank's position that we met our standing in this case by surrendering the original note that has a blank endorsement. The McLean case, the American Home Servicing Inc. versus Bednarik, which is a second DCA case, 132 Southern 3rd, support that. The copy being filed with the complaint, with the note, the endorsement that also appeared on the original that was filed, supports plaintiff's standing in this case. The second sub-issue to that argument that's been presented by the appellant in this case is whether or not we presented substantial competent evidence to support our right to foreclose, and we maintain that we did. While it's not necessarily fully fleshed out as to what documents the appellant believes that plaintiff's witness wasn't able to authenticate under the business records exception, the records that were introduced or authenticated included screenshots that the witness testified included proof of possession of the note prior to the filing of the complaint, the default notice, other goodbye letters discussing the transfer of servicing between the servicers, a payment history, powers of attorney, and also assignments of mortgage. In accordance with this court's recent decision in Sauce versus Federal National Mortgage Association, I believe we did meet that standard in that Ms. Martin was able to testify that she was an employee of the current servicer who was also, by merger, the predecessor servicer, that she had worked for Bank of America also, who was the servicer before that. She was able to authenticate the records. She testified as to her knowledge of the record-keeping practices of both Bank of America, Resurgent, Capital Finances, and Shell Point. She also testified with regard to the boarding process that they do when a loan is received. They receive records from the predecessor servicer. They discuss with them the documents that they'll need. Those documents are reviewed for accuracy and audited before they are made part of their system or go live, as Ms. Martin said. If any discrepancies are discovered, they don't go live with that loan. This is all the information that was required of the witness in Sauce to be able to admit the business records into evidence, and that also comports with this court's decision in WAMCO and the 4th District's decision in Bank of New York versus Callaway, which is another 2015 case. And then, Your Honors, with regard to the trial court's denial of the motion for leave to amend, the bank would maintain its position that this was not an error for 2 reasons: that it would have prejudiced the bank, and that it was futile, and these arguments were both raised below. At the trial, in the transcript, prejudice was mostly what was discussed, but in the response or in the pleading that was filed by trial counsel below, the issue of futility was also discussed. Florida Supreme Court case, Levine, that was cited in my answer brief, discusses that the liberality of allowing amendments diminishes as the case proceeds. The basis which was stated for the amendment, that they just found out that we had the note, is sort of, it's invalid in bank's opinion. As we discussed earlier, the defendant had actual notice that the plaintiff had the original document. In the prior foreclosure action, there was no indication in the record that we didn't have it to produce in this case. There's no requirement that we produce it at any time prior to the trial, and there was no request for it. The Levine case that was cited in my brief upheld the denial of a motion for leave to amend 2 weeks before trial because the request was futile. The reason, there was no request for continuance that was made by the appellant as an offer to cure any prejudice that might have been made to the bank, but the prejudice obviously being that the bank was not prepared to rebut or address an expert witness, did not have an expert witness of its own who had been able to authenticate or to review the original note that had been filed. With regard to the granting of the motion in limine, it's bank's position that the expert did not have anything to provide to the court that would have been technical or particular, that the court did not need an expert to aid in deciding the issue of whether the original note had been filed. There was no testimony regarding the authenticity of the signatures, and the expert did not purport to provide such testimony. The second expert that was purported to be produced by the defendant was going to testify with regard to the securitization of the loan, which, having already established our standing by production of the original note, we did not, the trial court did not need the aid of an expert to discuss securitization and the standing of the plaintiff in the matter. It's bank's position that if an error is found, it's harmless error, as there's not a reasonable probability that a different result would have been reached by the trial court. Again, there was really no allegation that the defendant did not claim to have signed the note. There was no actual evidence that the signatures on the note were not authentic. There was, the plaintiff had met its burden, improving its standing and production of the original note, and there was no need for an expert to aid the trial court in deciding the factual issues in this matter. One moment, Your Honors.
Yes.
I believe I've addressed all the issues that I needed to, Your Honors. Unless you have any more questions, I would rely on the briefs that have been presented and request that the issue be affirmed.
Thank you.
Thank you.
Thank you, ma'am. All right, rebuttal? I think you have about 3 minutes of rebuttal, okay? Okay, you may proceed.
Thank you, Your Honor. Michael Huey for Doug Diedrich. I appreciate your hearing from us today. I'm going to start off, and I'm going to go back to some of the questions that were raised and try to weave just a final response here about the question of standing. Really, for the bank to establish its standing, it needs to do one of two things. It either needs to show its possession of the note, or it needs to come forward with an explanation of why the original is not being produced. Copy is not going to be good enough, and usually the typical way to do that is through a lost note count, which they did in the first case, but not this time around. Now, it's also notable that they relied upon judicial notice, but going back to Judge Sleet's question about whether the actual original was actually admitted into evidence, if you look at page 208 of the record, that is where the list of the exhibits that were admitted, you're not going to see the original note being admitted into evidence. 209 also is what the defense had put it in.
If I may, if
Yes.
authenticity was an issue, again, because the transcript just arrived, you
Right.
could help me answer that.
Sure.
Did your client come forward and testify, that's not my signature, I never signed that, that is not the correct thing?
He did not testify to that, and even so, even if you accept that it was, these are authentic signatures, it still doesn't excuse the requirement to produce the original. A copy of the original is still an original, and it's still a requirement, either you come forward with your lost note count or you produce the original, so.
And I guess what my question was geared to counsel, when she said that we were prejudiced and not raising this as an affirmative defense. Well, one way could be bring in the client. Let's, this is a trial. It's not
Right.
by summary judgment. This is a trial. Put your client on. Go under oath. That's not my signature. Boom, right there and then.
I don't even think he's going to say that. All we're asking really simply is the court to hold the bank to its burden of coming forward with the original.
Well, as I understand it, it's not your client's position that he didn't sign the note. It's that the bank failed to prove possession in accord with the evidence rules.
That's correct.
For the production of an original.
That's correct. And I'm just going to add to that. I mean, even if you accept everything about their ability to show possession by the possession of the note endorsed in blank, that's only half of the analysis. You have to have possession so that you can surrender it to the court in connection with going forward with the foreclosure. It's to take it out of the stream of commerce. That's really the point of requiring the production of the original.
But the bank presented an argument that it had already filed it with the court as of June 4th, and it filed the original with the court, which is a surrender, and like the Clark case, they then introduced a copy.
Okay, my response to that would be the taking of judicial notice only shows at most that the two documents matched. If the court had taken as evidence Mr. Kelly's testimony, Dr. Kelly's testimony, that tends to show that what was actually produced, that was filed in the record of case number 1 in September 2009 is only a copy, because the bank has taken the position it's the same document. So I think at most, the judicial notice shows that the documents match, but it still doesn't tell us whether there was actually an original. And again, going back to page 208 of the record, there is nothing in there indicating that the original was moved into evidence in this trial in case 2.
It didn't.
I'm looking at the transcript, page 25,
Okay.
and I quote, this is the court indicating, apparently I am judicially noticing a few things, colon, the original note, what purports to be the original mortgage, the original assignments, and the copies of the recorded assignments, as they all appear in the earlier court file. So just taking that, I was just skimming and this
Right.
jumped out. Can't this be what the bank's arguing, that the court did take judicial notice of the original?
Well, under 202.06, you can, what it says is that you can take notice of the fact of filing, but whether it's authentic, even the court recognized that that's a separate issue, and I think a member of the panel had asked that question. And if you want to, reading the procedural rules together, 202 is only part of the story. If you look at 90.953, the admissibility of duplicates, again, I don't think there's any question that we dealt with duplicates in this particular case the second time around. Again, none of this relieves the bank from its burden to produce the original.
If the strategy at trial was going to be to hold the bank to its evidentiary burden on production of the original, why wait until the bank files the purported original note to try to inspect it? If there, and to carry the thought all the way through, if you could have done it earlier, why would it have been an abuse of the trial judge's discretion to say doing it when you did it was too late?
I mean, that point is, well taken, Your Honor. I think that if anything, if prejudice were based off of delay, I think there's delay on both sides. I'm not trying to excuse what, my side of it did, but, again, this was a case that was filed in October 2012.
And to follow up on that comment, I've speedily read through this transcript. The defense did not object to the introduction of the screenshot from Bank of America showing that the plaintiff possessed the original note March 31st, 2004 prior to filing the suit. So if you're going to be true to your defense, you object to that. There was no objection at all. And then the objections throughout the trial are simply hearsay, and I'm not so sure that they're legally sufficient to put the court on notice of a particular error.
I did take a look at it. You're talking about Exhibit 2 of the plaintiff's Exhibit 2? Yeah, if you take a look at that, I mean, if you look at the, again, I understand that you've only gotten the transcript, but later on, the trial judge, and I don't really understand what this actually shows. I mean, it shows that that the bank may have possessed it as early as March 2004, if I'm not mistaken. But again, that was about when Mr. Diedrich entered into that note with Countrywide. So I think there's even a question about that. But even so, again.
All right, we need to wrap it up.
Okay, I understand. If you just, if you take anything away from it, the importance is that it has to be surrendered, taken out of the stream of commerce, and we respectfully ask on that basis that the court reverse the judgment of foreclosure. Thank you.
Thank
Very
you.
good. Thank you both.